contractor agreements. So when you go on Upwork, when you go on Fiverr, when you go and hire someone from a Facebook group, and you hire them as a contractor to build something, an IP on your behalf, and you pay them money for that IP, if you don't have a proper contract, at the end of it all, they own your IP and possibly they have a claim to your business itself. So I'd like you just to kind of walk us through this and how to protect ourselves from that.
I mean, the solution is really easy, a strong contract.
Okay.
Employees, there is a default presumption that anything that they create for you is owned by the business. They're your employee, so they're working on your behalf. Contractors, it's entirely different. You're hiring a deliverable or a service, and you would think if I'm hiring them to write copy or I'm hiring them to create some sort of IP that you would own that. Unfortunately, the law is not that simple. There's a default presumption that the contractor actually owns it and they are giving you a license to use that during that relationship. So absolute easiest way to do it, strong independent contractor agreement that has work for hire provisions and assignment provisions. So any sort of rights, they have to assign it to you at the end of it.
I'm going to come back to contractors because I got some more there, but it's going to kind of fall the same with employees. So I want to do it all at once for efficiency. So employees. And I want you to head this on twofold. I need employee agreements for sure. But I also want you to address what is the definition of an employee and what happens when I hire someone and give them a contractor title but treat them like an employee.
I think there are 50 different state definitions of what an employee is. But basically, an employee is someone who you are hiring for their time.
Right.
They are coming to work for you. You're building a team. They are working for you.
You're telling them what to do, how to do it, and when to show up. And a contractor is someone who you're trading money for a deliverable.
Exactly.
Okay.
So when you treat a contractor like an employee, they become an employee. And then all of a sudden, all of the tax obligations, the benefit obligations, all the, people would talk about Obamacare and things like that. All of that translates into you as a business having basically fork out a lot more money. And if the risk of misclassification is that other than the benefit side, if they are not highly compensated, you get into overtime liability. Like, are these people entitled to overtime? You see how these very seemingly high paid executive assistants working for celebrities all of a sudden are said, I had to work every single day, for 14 days straight. And for like 20 hours a day. So I should be entitled to overtime for all those extra hours that I paid. So, there are tax implications, there are benefit implications. It just gets a lot more, the risk of misclassification gets expensive.
Okay. And what is that? Can you quantify that for me? Like, what's expensive? Do I get fined? Do I have to pay it all back? Do I have to pay a multiple of it all back? What do I have to pay back?
The risk of misclassification is it's going to be liquidated damages under the FLSA, attorney's fees, fee shifting, things like that, as well as just all the attendant, benefits and costs and things like that you would have to give
FICA and all that other stuff. Okay.
Exactly.
All right. Got it. So I want to move on to a couple things that we generally put in contracts, why they need to be put in the contract, and what the reality is. Non-competes is where I'd like to start. Because non-competes, it's a very interesting thing because it's really, really difficult outside of an exit or a sale of a business. It's a very difficult thing to enforce.
Virtually impossible now.
And on top of that, I just want to go one more level because I've actually seen where previous employees have contacted new employers and threatened to sue them over non-competes that can't be enforceable. So just kind of walk me through all that and how does that all work?
Yeah,
for contractors and for employees.
So for contractors, well, let's start at basics. Non-competes, I think that they have a place, they have a purpose. In the scenario that they would use in law school is like you have a business that developed some sort of process and you have this employee that's so integral and you teach them this process. You don't want them to be able to leave and then immediately compete against you. Mm-hmm. Times have somewhat changed. The FTC has definitely come out and said non-competes are absolutely unlawful. There's some litigation about whether or not that rule will actually be enforced. But California, it's virtually impossible to have a non-compete anymore unless you can really show that this employee has some sort of specialized knowledge and somehow they're going to compete against you. And even still, there's not a whole lot that you can do. Now, the way to enforce that is to really kind of pivot to your NDA and focus on, that employee's use of confidential information. So there are tools there, but including.
But I can't go stop an employee of mine from working for any other. You can't work for any other healthcare companies
No.
Okay. So now let's talk about contractor agreements. I myself have a contractor agreement with my clients. So let's say one of my clients wanted to keep me. Okay, I'm in the healthcare space. You now can't work with anyone in the healthcare space for 12 months after our contract is closed.
So
enforceable?
FTC is going to say no. As counsel for the business, we would say yes, and we would pretty much pivot and not harp so much on that non-compete language, but to say, you have this information that the only way that you can provide services to that other business is by using our own confidential information. The problem is that gets incredibly messy and usually requires litigation. So has state law kind of trumped a lot of this? Yes, it's going to be incredibly difficult, but it's still possible.
Okay, that's great. So I want to throw it in my contract just in case. Or what's your opinion? So I come to you, Ryan, and I say, hey, I want my employees and my contractors to all have non-competes. What do you say to me?
I say no.
Okay.
Unless it is reasonably tailored in scope.
Okay.
And really, I would focus more on buttressing or building up your NDA.